All right, I want to bring this into the fold. It says Harvard agrees to relinquish early photos of enslaved people, ending a long legal battle. Harvard University will relinquish 175-year-old photographs believed to be the earliest taken of enslaved people to a South Carolina museum devoted to African American history as part of a settlement with a woman who says she is one of the subjects' descendants. The photo of the subjects identified by Tamara Lanier, as her great 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 grandfather Whitney, whom she claims Papa Whitney and his daughter Delilah, will be transferred from the Peabody Museum of Archaeology and Ethnology to the International African American Museum in South Carolina, the state where where they were enslaved in 1850 when the photos were taken, a lawyer for Lanier said on Wednesday. The settlement marks the end of a 15-year battle between Lanier and the esteemed university to release the 19th century daguerreotypes.
Yeah, that's the type of picture.
Okay, daguerreotypes, a precursor of modern day photographs. Lanier's attorney, Joshua Kosoff.
Daguerreotypes, the daguerreotypes, I think it is.
Okay.
Go ahead.
Lanier's attorney, Joshua Kosoff, let me make this bigger. Kosoff told the Associated Press that the resolution is an unprecedented victory for descendants of those enslaved in the U.S. and praised his client's years-long determination in pursuing justice for the people she had identified as her ancestors. I think it's one of one in American history because the combination of unlikely features to have a case that dates back 175 years to win control over images dating back that long of enslaved people. That's never happened before.
Ask you a question.
Mm-hmm.
That's a nice victory for this family. What does it do for Black folk in general or for the country in general?
Well, right, because now I look at this, it's going to a museum in South Carolina.
It was already in a museum.
No, it was in the possession of Harvard University at their archaeology department. Now it's being transferred to the International African American Museum in South Carolina.
Hold on one second. Everybody in the world knows this major educational institution. Scholars from all over the world visit and request permission to access their files. And they do. Now, you got it in some place in the backwoods South, excuse me, but it is the backwoods South. And now you've restricted access to all of this information to something that makes you satisfied as a family. Good. But what did it do for Black folks? And what did it do for the instrument, for the process of research and historical accuracy?
Well, it says negotiations between Harvard and Lanier lawyers resulted in a settlement that included the removal of the images from Harvard's ownership. So I guess this is about ownership, and she probably did get some type of financial restitution from this. So she has ownership of the photos, and I guess she is allowing it to be displayed at the International African American Museum in South Carolina.
Anything for the rest of the Black folk who are probably in these images. It doesn't do anything for pushing the instrumentality of historical accuracy. It does not do anything for understanding the Black experience because you put it in a little niche over here. You achieved a Pyrrhic victory. You won the battle, but you lost the war.
Well, I think it's more so about ownership because it says that, she sued Harvard alleging the images were taken without Whitney's and Delilah's consent.
I got that. But
so here's my question. So it's not even a question. This is how I'm seeing it. when you are suing these entities and these establishments and these institutions for ownership, especially when it comes to your specific lineage, whether it's a family or community, this case, this type of victory can probably help other cases of people coming forward wanting to take ownership of what is
Yeah,
belonging to
well,
them.
let's look at this legally. All right. And this is not advice to anybody, but it's just an observation. This stuff has been dedicated to the public for 180 years. Now, let's supposing some researcher wants to come in and say, I want that photograph. I'm going to use that photograph. Now, relative to Harvard, the family may have a claim against Harvard's use, but if a third party comes in, there's nothing they can do about it because it's been dedicated to the public for 180 going on 190 years. So what winds up happening is effectively anybody outside of Harvard that wants to use it can use it, and there's not anything the family can do. So what did they get? It's a Pyrrhic victory. It looks like, oh my God, we can go dance and sing and do a line dance and celebration and praise Jesus and all of this, but it didn't do anything. And we got once again trapped in the dead end of celebrating appearances without dealing with the reality. Now, that's what I'm talking about.
Well, you're looking at it, and I get what you're saying. I'm not disagreeing with what you're saying. I'm just looking at it on how can a case like this, a victory like this for this particular family, how can it help me or someone else
It can't help you.
who is
But
seeking ownership, of their
yeah,
family lineage?
you filed infringement violations with YouTube, have you not? Yes, we talk about it. But the bottom line is if you use the pictures and you acquire them from previous production with Harvard, other than the fact that they published the stuff, if you got an independent source of it where it had been published by any other entity in the last 180 years, nobody could do anything to you. You'd use it all you want.
Well, I didn't find an infringement against YouTube.
No, I mean, we're not against YouTube, but against people that use YouTube.
That use my content.
That's your
YouTube,
content.
right? YouTube is just a platform that I'm displaying my content on, and I
Yeah.
have a contract with YouTube, and I get
Yeah,
paid
but
for it.
here's the thing.
So
You
she didn't
have
wait a minute. Let me just compare it to that. She didn't have a contract with Harvard for her photos to be displayed there. See, that
didn't
goes
have
back
to.
to
It's too late.
ownership.
It's too late. For
Well, that's
example,
why she sued them.
I know, but it's way too late to do anything about it in a real purpose. In other words, Article 1 of the Constitution sets forth the right to get exclusive usage of intellectual property. Okay, it's called a copyright or a patent. All right. But the patent and the copyright only last for a specific period of time unless it is deemed in the national interest to extend the copyright or the patent. All right. Now, if you have just published the stuff and thrown it out there, and you've thrown it out there in 8, 9, 10 years later, somebody says, oh, that's interesting. Somebody posted this on such and such Atlantic magazine and no copyright was claimed. Somebody put that out there, and without the protection of the copyright, it's dedicated to the public. So you can't come back 150 years later and say, oh, nobody did this on our behalf. So now we, against the people that originally came up with it, who didn't protect it, we want some rights versus them. Okay, you have the rights versus them. You reached a settlement. Now, what can you do with it? What copyright act are you going to presume to operate under? None, because it's been out in the public for 170 some years. So what protection did you just get? You
She
see
got
what I'm
protection.
saying?
I
In
get
other
what you're
words,
saying, but she got protection of ownership. She won the
yeah,
case.
but she can't do anything with it.
So Harvard had possession and ownership of those photos in their archaeology department, and only the students and then the people of that department had privy to those photos, or Harvard would use those photos in any publication that they said they which however they please. She sued them for ownership. She finally won after 15 years. So now the photos are in her possession, and she is lending those photos to the public again, but to where she wants it to be. So it's more like, you control these photos of my family, and I'm suing you to have ownership of these photos. So you did what you want to do with the photos, but I want ownership of the photos to do what I want to do with the photos. So I could tell the story of my family, not have you tell it the way you want to tell it. So it all goes down to ownership of the photos.
That's a Pyrrhic victory. It's just like saying, okay, after 5,000 years, we stumbled onto 4,000 years, we stumbled onto an ancient Egyptian tomb, and they had all of the hieroglyphics up there. So we took a photograph of the hieroglyphics. Okay, you may have some rights to the photographs that you took, but do you have rights to the wall, the art depicted in the hieroglyphics on the wall? No, because it's too long ago. In other words, how is she going to get a copyright for something that's been in existence for that long?
Well, people do that. Copyright is just ownership of it.
Yeah, I know, but it's not in the public interest to allow copyrights to be posthumously, so to speak, assumed or acquired on stuff that is ancient. In other words,
I get what you're saying, but
how old are the photographs?
right. But they're over 100 years old.
Yeah, I know, but the point is, Harvard didn't even have a copyright enforceable against 100-some-year-old photographs.
But now she does.
No, she can't get from somebody what they don't have to convey. In other words, if Harvard had a copyright, fine, but Harvard's copyright is expired on it
Well,
long ago.
we don't know if Harvard had a copyright.
It doesn't make any
had the photos in their possession, so
Well,
now she has it in their possession.
In possession or otherwise, the copyright, the intellectual property rights that the Constitution allows Congress to set up laws to respect, none of them are going to grant anybody any kind of copyright for 150 years, 170 years. You can take 1873 single action Colt Frontier.
So you're saying because the photos were over 100 years old, you can't copyright that, even though
No, you can't. No,
photos.
you can't.
Why not?
I'll give you an example. Let's take the 1873 Winchester, or let's take the 1873 Colt single action, or let's take the 1911 Browning design Colt 45 automatic. Let's take the last one. If you're in the Second Amendment, you can get a 1911 exactly the same as per the copyright or the patents on what John Browning designed for the U.S. military that they adopted in the 1910 and declared the 1911. I have a bunch of them. I'm wearing one right now. But the bottom line is this: you can get them from Colt, you can get them from Smith and Wesson, you can get them from Kimber, you can get them EAA that's made in the Philippines, you can get them from Wilson, you can get them from innumerable sources right now, made exactly as per the original patent designs. Okay, look, what I'm trying to tell you is this 114-year-old
175 years ago.
This 114-year-old design is no longer subject to copyright protections. Anybody can do anything for it. If you wanted to use the photos, there's no way she could enforce anything against you.